SJC-12557, Raymond Collazo v. Commonwealth.
Mr. Hirsch, good afternoon.
Good afternoon. If it please the court, David Hirsch, Mr. Chief Justice David Hirsch representing Mr. Collazo. What we're dealing with in this case is obviously a horrible tragedy, but the Commonwealth's case fell short in several different ways. One, failing to prove to a reasonable moral certainty that the injuries to the child leading to his death were inflicted. Second, that the mechanism by which the Commonwealth claims these injuries were inflicted actually exists. And third, that assuming they were inflicted by that mechanism, that Mr. Collazo, rather than the child's mother, Ms. Pagan, can be found beyond a reasonable doubt to be the person who inflicted them. Going to that last issue first, I think I cited the cases of Russell and Croft, but I left out what I think is the most important quote from both of those cases, repeated in both of those cases, that in a case resting entirely on circumstantial evidence, the circumstances taken together should be of a conclusive nature and tendency, leading on the whole to a satisfactory conclusion and producing, in effect, a reasonable and moral certainty that the accused and no one else committed the offense charged. That's not here. I think this case is remarkably similar to the Berry case, where there was, in fact, more evidence against the defendant than there is here, that he had taken the child into a separate room earlier that day and that another child in the home heard hitting, that he had hit the child before. There's none of that here. There's none of the evidence that has been found in case after case to be sufficient to choose which person was the one who could be found guilty of inflicting injuries. Here, we have several reasons why. Not only do we have the absence of any record of hostility, not only do we have appropriate response, the various other characteristics I mentioned, we have here a great deal of confusion and a great deal of contradictory statements within each of the Commonwealth's witnesses about when the injuries occurred. We have people saying, oh, it must have happened a few minutes, one doctor saying it must have happened a few minutes before the call was made to 911. But that would I thought the court was about to ask a question, but that would entirely defeat the claim that it must have been incurred when Mr. Collazo was alone with the baby at water at 3:30. We have various doctors saying, no, it couldn't have been a lucid interval, but on that same doctor, I believe that's Dr. Davis, saying, well, hypoxia can come on over a pretty long length of time, so we really can't know when it started. This is not the kind of case where the experts for one side say one thing and the experts for the other side say something else. It did happen here, but it doesn't matter, as we all know. It's not even a case where several of the Commonwealth's experts disagree with each other. There was disagreement within the opinion of just about every one of them. There were acknowledgments of ignorance on the part of, say, Dr. Richmond. Well, I haven't kept up with the literature. And there was just no basis here for finding that it was, excuse me, Mr. Collazo rather than Ms. Pagan. There are a whole lot of cases that have been cited by both sides that present such different circumstances than here. Say, Finney, overwhelming evidence that the defendant, one who killed the victim, that he had said to the victim's boyfriend, no, she isn't here, closed the door on him. Later, the victim was found in his bedroom, dead.
But here, the Commonwealth, I gather, has argued. You have medical testimony that indicated, although disputed, that the cause of death was abuse of head trauma, and that the baby appeared to be fine at the time of the last feeding by Ms. Pagan at about, I forget, 1:30 in the morning, and that he was the person solely dealing with the child between then and 7 a.m. when he said something's wrong.
And we also have the testimony of one doctor that the injuries were incurred several minutes before the 911 call, which could implicate equally either parent. And we also have the testimony of several experts.
Why is that? Because I thought the evidence was that he presented the child to the mother
Yes.
and said something's wrong.
Yes.
So
did.
are you saying it would have occurred after that?
Well, this one doctor, I believe it was Dr. Davis, said it was a few minutes before the 911 call.
Well, how long between the time he said something is terribly wrong and the call to 911?
I can't say that, Your Honor. I don't know.
So I assume not very long.
I assume not very long, but
But it's not reflected in the record.
it's so contrary to what all the other doctors say. And you have various doctors saying various other things could have caused it that would have taken a longer time. Hypoxia, for instance, various kinds of coagulopathy, that even could have been caused by resuscitation efforts. The second issue is whether there's proof that this child died of inflicted injuries at all. Dr. Booz, for instance, said that the initiating event is a brain injury causing respiratory arrest. But on the other hand, he agreed the initiating event could have been respiratory arrest causing brain injury, the opposite way around, although that wasn't his opinion. So when a doctor says, it's not my opinion, but it could have happened, cannot possibly be proof beyond a reasonable doubt. If it were just Dr. Booz, that would be an issue, but it isn't. Dr. Booz talked about the sheared bridging veins being the predominant theory of shaken baby syndrome, but there was no MRI here, so nobody could tell if the bridging veins had sheared. If the court will give me a moment, please. We have the extensive retinal hemorrhages. We have various people saying, well, that's clearly could only be the result of abuse. But we also have some of the same people saying, well, Dr. Richmond saying she hadn't kept up with the research. Dr. Davis saying it was unclear to him how it happened. Dr. O'Connor recognizing a dispute in the medical community about its meaning. Dr. Booz saying abuse is the most common cause, but can also be caused by DIC, a kind of coagulopathy.
But aren't we obliged to view it in the light most favorable to the Commonwealth, which means take their best experts or the best testimony of each of the experts and put that together and say if the jury could believe that and find beyond a reasonable doubt that the baby died from abuse of head trauma as opposed to natural causes, that suffices for purposes of this?
Well, that's a double question. One, of course, the jury is allowed to choose which testimony, and this court must look at things through in the light most favorable to the Commonwealth. I tried yesterday looking up what that really means in the light most favorable to the Commonwealth. I was unsuccessful in finding any cases defining it. Does it mean that we have to ignore parts of the Commonwealth's case that dispute the Commonwealth's case, of individual witnesses' cases that dispute their own testimony? I don't believe so. Absent further questions, I see that my time is up.
All right, thank you.
Thank you.
Mr. Wendell. Before you get started in this case, Ms. Pagan was also charged?
Yes, Your Honor.
She tried at the same time as the defendant?
She was not, Your Honor. Good afternoon, may it please the court. Assistant District Attorney John Wendell for the Commonwealth. Ms. Pagan was not ever actually tried. The Commonwealth ultimately disposed of her charges with, I believe it was a null pros. She testified on behalf of the Commonwealth in this case. And
But she was initially charged with murder, wasn't she?
she was, Your Honor. That was based on, I would gather, the initial phases of the investigation, where there was some question as to which parent might have done it. However, Your Honor, for purposes of the sufficiency claim, which the Commonwealth's position, as you pointed out, is that the evidence was sufficient and that therefore the single justice did not err in denying the defendant's petition. For purposes of the sufficiency claim, Ms. Pagan testified, "I did not shake or otherwise injure my baby." And therefore, in the light most favorable to the Commonwealth, she did not shake or otherwise injure her baby. So that rules her out as a possible individual to have committed murder in this particular circumstance. So that goes to the first issue that the defendant raised. Who inflicted this trauma, assuming it was inflicted? It can't possibly, in the light most favorable to the Commonwealth, have been Ms. Pagan because she denied having done it. So according to the expert opinions, Dr. Boos opined that it was probably after the 1:30 a.m. bottle feeding, most likely after the 1:30 a.m. bottle feeding, certainly after the earlier feeding at which the baby smiled. And Dr. Davis opined that it was minutes to many minutes prior to the 911 call. Based upon the whole circumstances of what happened at the house over the course of that afternoon, evening, and following night, the only four individuals who were in that apartment were Pagan, the defendant, the child, and the child's older sister, who was 18 months old. Ms. Pagan testified that his sister never injured him and was asleep during the evening portion. She testified that she did not do it herself. By process of elimination, the only person then who could have done this to the baby is the defendant himself. So in the light most favorable to the Commonwealth, there was substantial evidence that he was the only person who could have done this. Now, the defendant has brought up Barry in those circumstances. There is no denial by the mother in Barry of having injured her baby. Had there been such a denial in Barry, then there would have been sufficient evidence to prove that Barry, and not the mother, was the individual who committed the murder. But that didn't happen in that case. That is the fundamental distinguishing point. As for the cause of the death, the Commonwealth had multiple experts. They testified at length, and the ultimate opinions of those experts were that the baby died of abusive head trauma. And yes, there were certain circumstances in which they suggested that things were possible and so forth, but the general testimony in the light most favorable to the Commonwealth was that those things were theoretically possible but had not occurred in this case. Furthermore, going to the question of what the light most favorable to the Commonwealth means, I forget the name of the case. I believe it's actually mentioned initially in Lattimore. However, part of that is all inferences to the Commonwealth and all credibility determinations to the Commonwealth.
Is that Virginia v. Jackson?
I believe so, Your Honor. I believe there are several cases. I believe Jackson is the first. Lattimore, I believe, discusses it as well. There are multiple other Massachusetts cases that I can't recall off the top of my head. So that's all inferences to the Commonwealth and all credibility determinations to the Commonwealth. Credibility determinations are generally for the jury to make, and the jury has the right to credit or discredit any statement by any witness. And therefore, in the light most favorable to the Commonwealth, the experts, when they suggest that there is some manner of weakness to their own opinion, the jury is entitled to discredit that testimony. That, no, actually, we believe that the opinion is rock solid, ironclad, and this was, in fact, the cause of death. So, just in general, the expert's opinion was that this was caused by abusive head trauma. Assuming that is true, then somebody must have inflicted it, and as I said, the only person who could have inflicted it within the time period set by the experts was the defendant, because the mother denied injuring her baby, the sister did not do it, and there was no one else in the apartment during that time. If there are no further questions, I would rest on my brief.
Okay, thank you.
Thank you.